Negotiable Instrument Act of 1881 as amended in 1882, Part 3. Consideration. Valuable consideration. 52.1. Valuable consideration for a bill may be constituted by A. Any consideration sufficient to support a simple contract, or B. An antecedent debt or liability. Form of bill. 2. An antecedent debt or liability is deemed valuable consideration, whether the bill is payable or deemed or at payable on demand or at a future time. For holder for value. 53. Where value has, at any time, been given for a bill, the holder is deemed to be a holder for value as regards the acceptor and all parties to the bill who become parties prior to that time. In case of lien, where the holder of a bill has a lien on it, arising either from contract or by implication of law, he is deemed to be a holder for value to the extent of the sum for which he has a lien. Accommodation party, and this is really important. An accommodation party to a bill is a person who has signed a bill as drawer, acceptor, or endorser without receiving value therefor, and for the purpose of lending his name to some other person. Liability of party. An accommodation party is liable on a bill to a holder for value, and it is immaterial whether, when that holder took the bill, he knew that that party to be an accommodation party or not. When you guys are signing your negotiable instruments in blank, you are unwittingly and unknowingly becoming an accommodation party who carries and bears the liability of making the holder for value whole again by providing remedy through tender of, dare I say, payment. Okay? So you want to rebut and rebuke the fact that you're an accommodating party because it is presumed or assumed that you are the accommodating party. And as an accommodating party, you bear the liability. All right? Holder in due course. Holder in due course, 55.1. A holder in due course is a holder who has taken a bill complete and regular or the face of it under the following conditions, namely, A, that he became the holder of it before it was overdue and without notice that it had been previously dishonored, if such was the fact, and B, that he took the bill in good faith and for value, and that at the time the bill was negotiated to him, he had no notice of any defect in the title of the person who negotiated it. Title defect. 2. In particular, the title of a person who negotiates a bill is defective within the meaning of this act when he obtained the bill or the acceptance thereof by fraud, duress, or force and fear, or other unlawful means, or for an illegal consideration, or when he negotiates it in breach of faith, or under such circumstances as amount to a fraud. This typically is what is happening to you guys, ladies and gentlemen, because you're not qualifying your endorsement. You're not giving instructions on how to negotiate the instrument on your behalf. You're signing it in blank. You become the accommodation party by and through presumption and assumption of law, and thus you bear the liability. The fact remains that they are extending to you an application. They are giving you the application because they desire something from you. That is your credit. Okay, what they're seeking from you by extending the application is for you to extend to them credit. All right, the offerer is always the debtor, and the acceptor is always the creditor who gets to stipulate the terms and conditions. Okay, very important. Right of subsequent holder. 56. A holder, whether for value or not, who derives his title to a bill through a holder in due course, and who is not himself a party to any fraud or illegality affecting it, has all the rights of that holder in due course as regards the acceptor and all parties to the bill prior to that holder. Now, in order for the dealership or the bank to become the holder in due course to be able to negotiate that instrument, they would have had to have given you something of value in return. And if they had given you something of value in return, they would have acquired your rights to that instrument. But because they have not given you anything of value in return, ladies and gentlemen, you still are the holder in due course. It's a matter of whether or not you understand these concepts, okay? They cannot take your rights from you. You have to grant them. And in this uneven, unfair, false and misleading and deceptive trade practices through the banking franchises, what they are in fact doing is stealing your rights, titles, and interest, all while not providing valuable consideration and compensating you for the value that you bring to the table. They are shopping around your credit worthiness from the application for the credit. They're taking your promissory note that's signed in blank typically, and they're converting it into an order to pay or pay to bearer on demand, and they are selling it at a discounted rate, and they are never giving you the funds for it. They then issue you checkbook money. Okay, checkbook money is nothing more than check kiting. Okay, if you were to do check kiting, which would mean to float a check on an account that doesn't have any of the funds in the account, in other words, insufficient funds on the account to draw the check, that is essentially check kiting. You would go to jail for that or be penalized in the court system for such an action. However, the banks seemingly get away with it. Your deposit of the promissory note actually creates the funds. So when the bank says that we lend the depositors money, they're really not telling you a lie. They're actually being honest with you. The question becomes, who's the depositor's funds that you are extending? And the answer to that is they're extending your own funds to you through your promissory note and application for credit. Presumption of value 51 or 57.1. Every party whose signature appears on a bill is, in the absence of evidence to the contrary, deemed to have become a party thereto for value. Presumed holder in due course. Every holder, and notice how they use the word presumed and assumed quite a bit. All right, so you have to rebut and rebuke these presumptions and assumptions because by default in law, everything always is presumed and assumed to be to your detriment and not your benefit. Presumed holder in due course. Every holder of a bill is, in the absence of evidence to the contrary, deemed to be the holder in due course. But if in an action on a bill, it is admitted or proved that the acceptance, issue or subsequent negotiation of the bill is affected with fraud, duress, or force and fear or illegality, the burden of proof that he is the holder in due course is on him. In other words, he has to prove how he obtained it, when he got it, who he got it from, and how he acquired it, and how much he paid for it, so on and so forth. Unless and until he proves that, subsequent to the alleged fraud or illegality, value has in good faith been given for the bill by some other holder in due course. Usurious consideration 58. No bill, although given for a usurious consideration or on a usurious contract, is void in the hands of a holder unless the holder had at the time of its transfer to him actual knowledge that it was originally given for a usurious consideration or on a usurious contract. Negotiation by transfer 59.1. A bill is negotiated when it is transferred from one person to another in such a manner as to constitute the transferee the holder of the bill. By delivery 2. A bill payable to bearer is negotiated by delivery. By endorsement 3. A bill payable to order is negotiated by the endorsement of the holder. Without endorsement 60.1. Where the holder of a bill payable to his order transfers it for value without endorsing it, the transferor gives the transferee such title as the transferor had in the bill, and the transferee in addition acquires the rights to have the endorsement of the transferor. Representative capacity 2. Where any person is under an obligation to endorse a bill in a representative capacity, he may endorse the bill in such terms as to negative personal liability. So, where any person is under obligation to endorse a bill in a representative capacity, he may endorse the bill in such terms as to negative personal liability. Endorsing 61. An endorsement, in order to operate as a negotiation, must be A, written on the bill itself, and B, signed by the endorser, and B, an endorsement of the entire bill. So the other thing that is important to note when you're endorsing something, let's say it's a promissory note for an automobile. You can actually allonge to the instrument your instructions on how to have it offset and discharged at the Treasury or placed with the Federal Reserve agent, who is then instructed to negotiate that instrument with the Treasury and verify it with the comptroller of the currency to zero balance the account, or to make whole the party for which you're negotiating the instrument. Allonge. 2. An endorsement written on an allonge or on a copy of a bill issued or negotiated in a country where copies are recognized is deemed to be written on the bill itself. So again, if you've already done this for an automobile, a house, or whatever you're doing, you can in fact use a copy of the contract, go ahead and write your intent on that contract, pay the invoice to the dealer, pay the retail installment agreement or the security agreement to the lender. You, of course, are the lender, and zero balance the account. Okay. And you can do that without recourse, for collection, done in good faith, void where prohibited by law. And that would be sufficient for correcting your mistake in the first instance of giving a blank endorsement. Partial endorsement. 3. A partial endorsement, that is to say, an endorsement that purports to transfer to the endorsee a part only of the amount payable, or that purports to transfer the bill to two or more endorsees severally, does not operate as a negotiation of the bill. Signature sufficient. 62. The simple signature of the endorser on a bill without additional words is a sufficient endorsement. In other words, if you're going to give a blank endorsement, that's good enough for them, ladies and gentlemen, but you need to protect your interest. You need to do a little bit of research. You need to do some studying about your endorsement and what your intent and purpose is. 2. Or more payees. 2. Where a bill is payable to the order of two or more payees or endorsees, or who are not partners, all must endorse unless the one endorsing has authority to endorse for the others. Misspelling payee's name. 63. Where in a bill payable to order, the payee or endorsee is wrongly designated on his name, or his name is misspelled, he may endorse the bill as therein described, adding his proper signature, or he may endorse by his proper signature. Presumption as to order of endorsement. 64. Where there are two or more endorsements on a bill, each endorsement is deemed to have been made in the order in which it appears on the bill until the contrary is proven. Disregarding condition. 65. Where a bill purports to be endorsed conditionally, the condition may be disregarded by the payor, and payment to the endorsee is valid, whether the condition has been fulfilled or not. Endorsement. 66. An endorsement may be made in blank or special. In blank, number 2. An endorsement in blank specifies no endorsee, and a bill so endorsed becomes payable to bearer. Special. 3. A special endorsement specifies the person to whom or to whose order the bill is to be payable. Application of Act. 4. The provisions of this Act relating to a payee apply with such modifications as the circumstance requires to an endorsee under a special endorsement. Conversion of a blank endorsement. This is very important for you guys to pay attention to because this is in fact what's happening to 95% of you. Conversion of blank endorsement. 5. Where a bill has been endorsed in blank, any holder may convert the blank endorsement into a special endorsement by writing above the endorser's signature a direction to pay the bill to or to the order of himself or some other person. Okay, and this is exactly what is happening to 95% of the people out there. They're giving a blank endorsement, which gives the receiver of that instrument the ability to go ahead and negotiate that instrument as they see fit, either pay to the order of or pay to the bearer on demand. And that's what they're doing with your notes for not having qualified your endorsement and giving specific instructions on how to negotiate your instrument. Restrictive endorsement. 67. 1. An endorsement may contain terms making it restrictive. Idiom. 2. An endorsement is restrictive that prohibits the further negotiation of the bill, or that expresses that it is a mere authority to deal with the bill as thereby directed, and not a transfer of the ownership thereof, as, for example, if a bill is endorsed pay only, or pay for the account of, or pay or order for collection. Right of endorsee. A restrictive endorsement gives the endorsee the right to receive payment of the bill and to sue any party thereto that his endorser could have sued, but gives him no power to transfer his rights as endorsee unless it expressly authorizes him to do so. If further transfer is authorized. 4. Where a restrictive endorsement authorizes further transfer, all subsequent endorsees take the bill with the same rights and subject to the same liabilities as the first endorsee under the restrictive endorsement. When negotiability ceases. 68. Where a bill is negotiable in its origin, it continues to be negotiable until it has been A. restrictively endorsed, or B. discharged by payment or otherwise. Or otherwise is key here. Okay? You could come back in and correct your mistake. So there's one of the or otherwises. You could set it off. You could come to an agreement with the holder. There's a number of different things that could be done here. You could tender another bill of exchange to offset the bill of exchange they currently are in possession of. All right. Overdue bill. 69. Where an overdue bill is negotiated, it can be negotiated only subject to any defect of the title affecting it at its maturity, and thenceforward no person who takes it can acquire or give a better title than the person from whom he took it had. When demand bill overdue. 2. A bill payable on demand is deemed to be overdue within the meaning and for the purpose of this section when it appears on the face of it to have been in circulation for an unreasonable length of time. 3. What is an unreasonable length of time for the purpose of subsection 2 is a question of fact. Presumption. 70. Except where an endorsement bears date after the maturity of the bill, every negotiation is, in the absence of evidence to the contrary, deemed to have been effected before the bill was overdue. Taking bill with notice of dishonor. 71. Where a bill that is not overdue has been dishonored, any person who takes it with notice of the dishonor takes it subject to any defect of title attaching thereto at the time of dishonor, but nothing in this section affects the rights of a holder in due course. Reissue of bill. 72. Where a bill is negotiated back to the drawer, to a prior endorser, or to the acceptor, the party may, subject to this act, reissue and further negotiate the bill, but he is not entitled to enforce the payment of the bill against any intervening party to whom he was previously liable. Rights and powers of holder. Rights and powers of holder 73. The rights and powers of the holder of a bill are as follows. A. He may sue on the bill in his own name. B. Where he is a holder in due course, he holds the bill free from any defect of title of prior parties, as well as from mere personal defense available to prior parties among themselves, and may enforce payment against all parties liable on the bill. C. Where his title is defective, if he negotiates the bill to a holder in due course, that holder obtains a good and complete title to the bill. And D. Where his title is defective, if he obtains payment of the bill, the person who pays him in due course gets a valid discharge for the bill. When we come back, we'll be getting into negotiations.